Perfect. Thank you. Best of luck.
Hello, good morning, everyone. So it's a pleasure to receive everyone for our session about the UK-US data breach framework. Let's just wait a couple of seconds while people are joining our session. And just an advice before we start and kick off with presentations and explaining a bit about our topic, just a heads up that we will have a couple of polls that will be launching in a couple of seconds. And you can vote about a demo or requesting like a one-on-one conversation with OneTrust representations, or even answer a couple of questions that we have in terms of how your organization is managing the compliance with the UK-US data breach and the overall framework that you are using to cover the compliance of international data transfers. But let's now kick off our session. And first of all, I need to thank my both colleagues here, Robert and Tumi, that accepted the invitation and will share a lot of interesting knowledge and comments and practical advice about the UK-US DPF and the UK-US data breach implementation. So Robert is Managing Director for Privacy and Data Compliance Services at Alvarez & Marsal, and Tumi is the Senior GDPR Specialist at Soho House & Company. So both colleagues here share also the same legal background and the compliance in-house adequacy and advisory for clients as myself. Because first of all, so let me introduce myself. My name is Marco Mendes. I'm Privacy Counsel and also member of the Center of Excellence at OneTrust. So I'm responsible both for the in-house advisory in privacy and data protection for our compliance program, but also for the product overall. Well, let's start our session just giving a bit of the items that we will explain today. And our approach here will be more like a fireside conversation. So we don't have a deck or anything else specific to show, because our idea is actually to discuss practical implementation points about the adequacy criteria, about our review of international data transfers, and the overall assessment process that you can undertake in your company to evaluate your international data transfers. If it's the first time that you are hearing or looking about the UK-US data breach, just a small introduction. We are talking here about the framework that involves a meticulous adequacy assessment, and it was approved in a joint assessment between the US government and the UK government to create a specific mechanism to validate and create the adequacy framework for international data transfers between the United Kingdom and the United States. This is a long assessment process because it started in 2021 when the Secretary of State announced the assessment for the US adequacy under the UK GDPR law. So this assessment covers not only privacy and data protection, but also the overall topics about information technology, about surveillance, and also about the mechanisms that safeguards the human rights and other fundamental rights to cover the same level of protection from transfers when you are transferring your data from the UK to the US. And now I want to open this discussion, and I think both Robert and Tumi has points to contribute about like the first discussion point that we had. So as now our audience understood about what's this type of framework, I want to give a question for both. So what does the UK-US data breach do and how does it work? So if you can explain a bit more about the details and the introductions, please feel free, and let's discuss this first topic now.
I'm happy to go first, Robert, if you were okay with that. Yeah, so Marco, obviously you've given us a great introduction. In 2021, the Secretary of State announced that the government would assess the USA for adequacy under the UK GDPR. And it's important that we differentiate here between EU GDPR and UK GDPR. And the assessment considered all of the criteria for adequacy under Article 45 of the UK GDPR to the appropriate extent. So although the Secretary of State concluded that the UK's extension did provide an adequate level of data protection and to lay the regulations to that effect, there were some areas that were highlighted as concerning. And there was a welcome for, or there was a ask for more specific areas and guidance as to ways in which data subjects' information or personal information wouldn't be protected if the protections weren't applied properly in practice. So obviously we know that the UK is having an extension to the existing EU-US data privacy framework, and those principles lay out the set of requirements that the businesses and organisations that want to self-certify or certify underneath the framework have to comply with in order to be deemed as adequate and sign up to the privacy framework. And I think it's noteworthy to understand that what we're seeing actually is this accountability principle in practice. And that's very, very promising in terms of understanding or knowing that personal data of citizens is going to be protected underneath this framework. But I think Rob can obviously speak to this, but it's noteworthy to obviously talk about the background and how we got here. And we're in this long, arduous, and sometimes concerning discussion of international transfers and US mass surveillance. So we know that the Irish DPC was Facebook, now Meta decision. It covered international transfers and it invalidated the Privacy Shield 2.0. And it's this reoccurring issue of mass surveillance under FISA, as we all know. And that was still persisting despite somewhat meager attempts to provide citizens with some sort of redress. So we had Biden with the executive order. We had the agreement in principle earlier in 2022 for that transatlantic data privacy framework. And before that, we also had the guidance on supplementary measures. So we're seeing this reoccurring thing of trying to implement appropriate safeguards for the transfer of information from the UK to the US. But I think it's really noteworthy that the data privacy framework, from what I've seen, from what I've read, from what I've spoken about with colleagues and people within the network, is that we are getting some more protections, more than what we've seen previously under the privacy framework. Obviously, we're going to talk about this later on. This is dependent on the current state of affairs and not what the UK has in mind or what they envisage for changing the data protection framework in the UK. But this is why we're here. And I think it's promising. I think it's noteworthy to also mention that Max Schrems, he described insanity as doing the same thing over and over again and expecting a different outcome. And then he likened that to what we're seeing with international transfers and all of these different mechanisms. So it will be noteworthy to see whether we are doing the same thing over and over again and expecting a different outcome with the data privacy framework. There's obviously going to be a lot of jurisprudence that comes with this. And I think that's the most exciting part for people like Rob and I, because we have a legal background. So the case law is where we find all the meat. And the obiter dicta as well, sort of judges' notes and things like that. But I'll hand over to Rob just to add to what I've said there. Thank you.
No, thanks, Tumi, and thank you also, Marco, for the introduction. And hello, everybody else. Good to have you join us. I think Tumi's done a very good job of sort of setting the scene here for today's discussion and what the UK-US data bridge is. You know, I think from my sort of simplistic mind perspective, you know, it's not sort of revolution. It very much, as Tumi sort of says, it's built upon a sort of somewhat sort of pockmarked history around sort of management of international data transfers under the EU GDPR, and it's the sort of effectively latest reincarnation around management of sort of adequacy. So in many ways, the UK data bridge is sort of post-Brexit terminology for what used to be just sort of EU adequacy. But I think there are some sort of variations, and I know we'll get into a bit of the detail shortly around sort of where some of the challenges are likely to be with this. But I think in many ways it builds upon the likes of the Privacy Shield, and obviously prior to that, the Safe Harbor scheme. You know, I think the mechanics are pretty similar in terms of certification of companies and obligations to effectively abide by essentially a set of principles and requirements that to a lesser or greater degree sort of reflect what we sort of see in UK and European sort of data protection rules, but we'll get into some of the particular specifics. I think the major difference, and Tumi's mentioned already, the executive order, is the fact that the US have had to now address a number of significant sort of EU and UK concerns around the point of particularly sort of use of European and UK data for essentially sort of surveillance and monitoring and effectively the roles of the US intelligence agencies and the like. And so, there are certain additional measures that have been put in place. And I think the main part is under the data bridge, effectively what are deemed UK individuals essentially have additional rights of redress under the US scheme. I think one of the things I'll just sort of pull out now before sort of handing back to Marco is some of the original sort of challenges of the Privacy Shield still exist. So I think one of the things that still hasn't changed is the fact that essentially this is an agreement, an international agreement that is effectively being overseen by the Federal Trade Commission, the Department of Commerce, and the Department of Transport, who effectively act as the de facto US regulators for essentially accountability for US parties receiving data under the scheme. It's worth flagging, though, that not all sort of US companies are necessarily regulated by those bodies. So, for example, financial services, a lot of the regulated business falls under SEC jurisdiction, which isn't actually covered by the executive order and the data privacy framework. So in some cases, it still may not necessarily be an option available to all data transfers, depending on the nature of the recipient and the organization and how they're regulated. But I think we'll get into some of the mechanics and detail now. But Marco, I'll hand back to you for now.
Oh, thank you very much, both. I really like the approach of our introduction and icebreaker, because both of you you cover different aspects of the framework, but I think there was a commonality in terms of the explanation about the continuity of the previous Privacy Shield and what we have as a similar approach and a similar content, and what needed to be changed due to the CGU ruling on Schrems 2. And I always like to wrap up this subject when we think about the key takeaways about the new EU-US DPF overall, as we are considering the UK-US data bridge as the addendum of this broader framework. So, due to the problems that we had identified in this Schrems 2 judgment, it's clear that this new framework tried to establish this international data framework in a more compliant level, covering, first of all, the facilitation of how you can make this data subject access the data and also exercise the redress mechanism that was an absent characteristic on the previous framework. So that was one of the reasons that we have established the new independent data protection review court in the US, and also several limitations that we have in terms of the access by US intelligence services from EU data. And now we will have probably in the long term the jurisprudence that Tumi mentioned, if those changes actually addressed the requirements of necessity and proportionality that the CGU established, that it was also one of the main characteristics that made the previous Privacy Shield uncompliant. But we spoke a lot about the legal part of the framework overall, but now I want to dive in a bit about the procedure that the company will need to undertake. So regardless if you think about that we will have in a future an invalidation, or if we will even have updates on the data privacy framework to make some kind of corrections, we have a truth now that business will need to certify under this framework if you will want to consider it your compliant instrument for the international data transfers. And couple of characteristics I also think about it that they are pretty straightforward for business. For example, when we think about the accountability of onward transfers, like the contracts and the measures that you need to put in your data protection addendums, and also in terms of how you will disclose the redress mechanism for the EU citizens, and how you will make the data subjects to access in an adequate manner this new redress mechanism. But we know that we have much more change that business probably need to undertake to actually qualify the certification in the right manner as it's provided in the rules of the framework. So for both Tumi and Robert, like what kind of change and what kind of steps would you recommend for business in terms of the change they will need to make on privacy notices, record of processings, contracts, and any kind of internal procedure and documentation that they need to disclose to guarantee that they will have the right certification procedure in this framework? So whoever wants to start, if you want to make the same dynamics, do me first and Robert afterwards, feel free to join.
Yeah, it's I mean, essentially it's best practice, I think, for UK organizations. If you were doing things properly before, you can continue on that path, and that is the road to success. I think the 16 supplementary measures as well that we find within the privacy framework are great for that standing in terms of where to place yourself and what you need to do. Again, that accountability principle in practice. I think the accountability principle, I always really like it from like a legal theory perspective, because essentially it's demonstrating how you comply, right? And then that sort of upholds the transparency principle as well in practice, because you're then communicating that to the data subject. So you've got things like performing due diligence and conducting audits. Rob and I both know, and Marco, you'll know as well, that that is part and parcel of any, contract signing or a vendor assessment that you may do, and that idea about this tertiary obligations that we have on processors and controllers and third parties as well. So that is steadfast within the data privacy framework. You've got secondary liability, for example. Again, that's something that we know is already within all of our GDPR practices. So doing that under the privacy framework isn't going to be a hard thing. I think it's really interesting as well how the privacy framework tackles HR data. So the application of notice and choice principles, for example. I remember some analysis that we did on the federal bill that came out for data protection. And there were some questions and comments that were had on how it would relate to employee data and HR data. So it's impressive and promising to see that that is within the privacy framework as well, and not something that's going to be scoped out. I think, I think I've actually covered enough for now. I'm going to pass it over to Rob, and then we can just bounce off each other.
Yeah, that's
what's going on.
Yeah, and again, I think, in many ways, the actual sort of certification application process for the scheme is a very simple one. In fact, if your organisation was already registered under the Privacy Shield, many of you will have found out that you've been effectively auto-enrolled into the data privacy framework. So from that account, it's really about essentially agreeing to effectively the requirements of the scheme. I think to Tumi's point, and as alluded to by Marco, the real challenge comes with how are you actually evidencing and demonstrating sort of compliance, and what does that mean to you as an organization? Some of the challenges, it's really going to depend. So I think first I would make a distinction between the extent to which essentially you're availing use of the scheme for your own internal sort of intergroup data transfers, and to what extent you can essentially apply your existing UK and European privacy policies and procedures effectively to sort of data subject to the transfers. And then the other element, as Tumi mentioned, is the bigger challenge of where essentially you're using this mechanism to validate data transfers essentially to third parties or partners or vendors, and the extent to which, as a sort of UK data controller, you still have general obligations around due diligence to validate the vendor. In many ways, I sort of see the DPF, the data bridge as a wrapper, very similar to relying on standard contractual clauses or binding corporate rules. It's quite easy to say, yes, we're going to use this, and it does allow for adequacy. The harder part is then actually working out where the pain points are for you as an organization in terms of managing that risk, developing effectively a program of assurance and monitoring, so that on top of the individual parties' obligations under the scheme itself, you as a data controller can effectively have some assurance that they're meeting these standards, those requirements are being met. And in many ways, I think this is sort of part of the challenge I sort of see with EU adequacy and the likes, that often we spend so much time in red tape getting all the contracts in place, worrying about sort of doing our transfer impact assessments and looking at legal basis and all of this. And often we don't spend enough time actually focusing on the operational challenges, which is actually, do we understand where our data is? Can we categorically define what data is going to be subject to a particular transfer or sharing relationship now? Is that going to change over time? How do we actually manage that in practice so that the legal teams and the privacy teams are made aware of any particular changes in scope of the data that's being transferred, or for that matter, the nature of the processing, particularly now. And again, sort of Tumi sort of touched upon the particular sort of challenges around liability. I think there will be more pressure under sort of this scheme. So albeit sort of having very sort of similar obligations to sort of previous and other existing sort of adequacy schemes, I do think just because of the nature of the challenge and concerns around particularly sort of transfers to the US, there will still be, or there is more likelihood that data protection authorities are going to be more engaged, particularly if they receive any complaints or queries around use of these mechanisms. So I think it's been able to have that defensible position, been able to align what is being effectively certified under the transfer scheme with what you're saying in your privacy statements, what commitments you're making to the data subjects, with the reality of how that marries up to the actual nature of the controls that are in place. Just adding on to that, I think, because I think we've also seen quite a shift around corporate governance in this space over the last few years, particularly around risks associated with global sort of digital supply chain, how we're using vendors and suppliers across different regions, and how it also cuts across effectively responsibility of senior management, where effectively you are sort of effectively signing up to or engaging through a sort of scheme of making public statements and public commitments, how that marries up with, for example, reporting obligations under ESG and corporate governance, sort of commitments to investors, and the potential for that also to be an avenue for potential claim or potential sort of actions and litigation in relation beyond just the requirements of the actual framework itself, but as organizations where we're putting ourselves out to make commitments to effectively third parties, how effectively we can justify and demonstrate sort of compliance. I think the bigger challenge is also none of these things are ever perfect. So I think it's also about prioritization and looking at where the biggest exposure is, and often that's typically around the more sort of sensitive sort of categories of data or higher risk categories of data, that if there is sort of unintended disclosure or use of the data, where there's likely to be far greater sort of consequences in terms of harm to the individual or exposure as well. So definitely, I think, getting your house in order in terms of understanding your data flows, the data mapping, how they align with your records of processing activities, how that aligns with what's certified. The last thing I would say as well is, particularly where you're looking at third parties and you're relying on effectively their certification under this scheme, to be very clear in understanding what they've certified. So I've seen it in a number of cases where organizations have said, hey, we've got Safe Harbor, or we're sort of certified under Privacy Shield, or we're now sort of covered under the privacy framework. But in reality, you then sort of dig into their certifications and you realize actually they're only covering their own internal data transfers, or it's limited to customer data, or it's limited to employee data, and it doesn't necessarily cover all of the scope that you need and their obligations as a vendor. So there's a lot to speak on this, but I'll hand back to you, Marco, so we can sort of open up the discussion a bit more as well.
Oh, that's excellent. I mean, those are brilliant contributions, and I think you both wrap up a very important point of the framework. It's about the monitoring, because we have a lot of business talking about the certification procedure, how to collect the adequate documentation to evaluate that you are a company that you can rely on this mechanism, you can use for your transfers. But after the certification procedure, we need to think about that. If data subjects will start to raise complaints in the redress mechanism, probably they will start to raise the complaints about the functionality on how you are managing internally the compliance with the framework. So you need to understand that if you do not have specific mechanisms to monitor, and Robert quote a lot of those mechanisms, like the review of the third-party vendors in terms of your due diligence procedure, how you update your inventory and you maintain updated your records, or how you are undertaking your transfer risk impact assessment, and how you are monitoring new risks that probably will originate due the change on your processing activity. Those are elements that, for example, if we look in the body of the framework, they are completely related with the choice principle, or the privacy notice disclosures, or the obligation to actually maintain a verification procedure to implement records of management. And if you do not have those kind of structures in your company, probably you will not suffer a problem in the certification procedure, but actually when a data subject will raise a redress mechanism, or if you are negotiating with a vendor that will require you to afterwards to disclose the evidence on how you are being compliant with the framework. So considering this topic, I think now we are entering in an arena to discuss about the actual legal challenge that will impact your business when you are starting to implement the framework. And I believe that just to speak about the legal challenges, we could stay for an entire hour, because probably these are the hot topic that we will see the jurisprudence originating different types of cases and understanding about the application of the framework in the next months. Just a couple of introductory topics before I hand over again to Tumi and Robert. I always like to pinpoint a couple of challenges that were already foreseen through the assessment of the UK State Secretary when they were doing the assessment of the EU-US DPF, and they were building the UK-US data bridge, and they already pointed some open points that probably future guidelines we need to address if we really need to understand the balance of the requirements between the UK GDPR and this data bridge. One of them is about the classification of the information that Robert already mentioned, because the UK extension definition of sensitive information lacks about terms of specificity. So if you are accessing this type of information, you don't have a targeted criteria, because there's an ambiguity in terms of the alignment of the content that we have in the Article 9 of the UK GDPR. Other kind of challenge that maybe we can foresee, it's about the automated decision rights, because the UK extension does not grant a substantially similar right to the UK GDPR concerning the decisions that are based solely on automated procedure. And this is something that probably data subjects can start to rely on the redress mechanism to fill this gap and to make the companies to go further and beyond the framework. And also in terms of the right to be forgotten and the consent withdrawal, because those open challenges are also related about the choice principle. So the UK extension lacks a substantially similar right to the UK GDPR's right to be forgotten. And we know that internally our jurisprudence already recognizes this as a strong right for the data subjects. And this also makes relationship about the level of control that data subjects will have about the data that are being transferred between the UK US. So it's also interesting to see in the future how the ICO and the other internal authorities will start to provide guidance about how UK organizations can identify the data that are safeguarded by the right to be forgotten and how to comply in terms of how you can transfer, but in terms of how data subjects can also exercise this right. But of course, we have much more challenge. I just make this opening point to warm up about our discussion, but I will now give the arena again for Tumi and Robert, because I want to hear for both of you, more for Tumi about the experience that she has as an in-house, what kind of challenge you were facing in terms of these open points of the UK-US data breach, and for Robert, what kind of challenge you were seeing in a broader spectrum about the clients and the other business that you give privacy advisory.
Yeah, that's fine. I can let Rob go first on this one, and then we can swap it over.
Okay, if I can manage to take my mute off, as always. Can you guys hear me?
Yes.
Yeah, sorry, I froze there for a little bit. Yeah, I'll keep it brief, and then maybe I can come back after sort of Tumi spoken. I think not to sort of dwell over all the sort of history of the Schrems challenges and sort of concerns raised by the European Data Protection Board, and as part of that, the various European data protection authorities who brought claims against, particularly where there were sort of transfers of data under essentially sort of public services to the US. This sort of deep-seated sort of, dare I say it, sort of lack of confidence in the US authorities and how they were going to use the data. And so whilst, as sort of Marco's mentioned, part of the new scheme has integrated a number of additional measures and mechanisms for redress that talk to the specific points raised by the Schrems decision and the decision of the European Court of Justice. A lot of those deep-seated concerns, quite frankly, haven't necessarily gone away, and it becomes more political in terms of effectively the balance of power between the EU or Europe and the US when it comes to where is our data, the types of organizations, the big tech that are effectively hosting and processing and managing a lot of our data. So, I think we will definitely sort of see legal challenges coming from sort of NOBU, so none of your business, effectively the Max Schrems sort of civil society body around this and challenging the points that you raised, Marco. I think fundamentally though, businesses and organizations need certainty, and my biggest gripe with all of this, quite frankly, I'm a consultant, so in many ways international data transfers helps pay the bills, right? It's the problem that never goes away and creates a lot of administration, a lot of burden on organizations. I'm not convinced it's the biggest risk when it comes to exposure of data and harm to data subjects in Europe, but it's definitely one of the major sort of hurdles and topics. I think it was interesting. I don't know if sort of people have noticed, but I think there was a legal challenge by one of the French MPs in September around the decision. But that, we're still waiting on a date for an actual proper full hearing and a final verdict. But there was an interim ruling by the CJEU around this, and at the time they found that there were insufficient grounds. So basically it was a sort of claim to say that the measures didn't go far enough, didn't give it sufficient rights to data subjects to prevent their data being effectively sort of accessed by US authorities. But that challenge was actually sort of pushed back at the interim level, at least, to say there wasn't sufficient grounds for urgency for effectively fast tracking essentially that review. I think there are fundamentally there have always been massive gaping holes with the adequacy sort of principle dating back to the EU Data Protection Directive, even looking at the standard contractual clauses. If you to look at all of these different mechanisms from a pure legal perspective, there are many ways you could drive a bulldozer through a lot of it. But in reality, I think what's important is actually companies need a degree of, effectively ability to have assurance around what's happening and certainty. And I think, rights or wrongs of some of these particular concerns and issues, it's a problem that unfortunately companies and organizations have to pick up the slack in dealing with, when it's actually this issue that should be dealing with being managed at that sort of intergovernmental level. Because fundamentally, the global supply chain is critical to most organizations. It's something that effectively is not going to go away. We've seen, at an individual level, certain countries try to bring in effectively data localization rules, either on the grounds of protecting sort of individuals' rights, or in some cases protecting national security and national interests when it comes to this. But in reality, it doesn't sit in terms of the real world sort of infrastructure that we live and breathe in terms of managing global and cross-border business. So I think there definitely needs to be that sort of political agreement. It's slightly blurred a little bit with the UK in this sort of post-Brexit juxtaposition, where essentially we want to maintain adequacy, we want to have all the benefits of it, but we almost have to justify sort of our ability and our sovereign right post-Brexit to be able to sort of forge our own path. And in many ways, I think the data bridge is trying to do this. I'm not sure it's necessarily the right way of doing it. I think, again, for a lot of my clients, they're operating across multiple jurisdictions, across Europe and beyond, where the idea of trying to apply specific rules or make a variation in how you treat and manage UK personal data versus other European data or data coming from other regions, it's just not practical. From a systems management perspective, from a policy management and accountability perspective, even if you're applying higher standards, it's often better and easier to apply that higher benchmark than it is to try and make sort of variations on every single sort of country level. So I do think it's sort of something where there may be some possibilities for flexibility, some areas of ability to generate value from data in a way where potentially it's not subject to very draconian consent requirements, or the risk associated with data sharing or use of data for secondary usage could be managed. But it's one where I think trying to do it outside of the effectively EU umbrella is probably going to cause more problems than it's worth for most UK data protection sort of controllers. So yeah, I think it's one where I'll let Tumi sort of talk about sort of her perspectives, but my view is I think firms need to sort of try and take a practical approach to this. I think it's not necessarily practical or easy to say, look, we're just going to localize all of our data on servers in Europe or the UK, because in reality, even if the data is hosted there, you may very well find that actually you're using managed services, or your vendors have service provider, staff and individuals who are based in other countries where it still triggers the transfer requirements. or it may be just from a resilience perspective or from a productivity perspective. You need to effectively maintain a global sort of framework and technology infrastructure where it's not necessarily convenient either to store all your global data within a UK or EU centre. So, you know, I think it's definitely an interesting one, but I wouldn't have, my own personal view is some of these sort of legal challenges, I wouldn't use that as a justification for not moving forward with your own programs or assessing your real risk when it comes to data management and how you're going to deal with things, just because in reality that should be sort of effectively part of your fundamental responsibilities anyway, from be it a UK GDPR or an EU stamped sort of GDPR perspective. But Tumi, I don't know if any of that made sense, but it'd be really interesting to get your views from that internal perspective about, you know, where you see the threats coming.
From an in-house perspective, I don't think we're jumping up and down with pom-poms and, you know, doing the cheerleading routine for the UK-US data bridge. And mainly because, Rob, you've already mentioned that it's that uncertainty. We've seen so many iterations of international data transfer mechanisms coming about that we still envisage there being some legal challenges to it, and also that actually our own programs have a higher standard of protection and even evoke the accountability principle at a much higher level. So, I mean, looking at the analysis that we did with our own legal team, we said, you know, it does do amazing things with regard to notice, choice, security, and again, those supplementary principles. There's a fairly decent level of protection there. You know, having to provide notice to individuals to uphold transparency, being clear on what we do with personal information collected, choice, you know, that's another one as well, giving the opportunity to individuals to opt out of that personal data disclosure to third parties for purposes that are obviously incompatible to what it was originally collected for. But we already do this in other ways. So, for example, we've got our privacy policies and our privacy notices that we've just done a massive review with the legal team. It's been a year-long activity that we've finally gone live with now. And that goes over and above what we have under the data bridge. Even with choice, we have the obviously CCPA or CPRA opt out of data sale through our OneTrust portal, and we've got CCPA addendums to all of our major contracts and also to our product launches as well that we do. So we work very closely with our digital team to do product launches, and we always have a CCPA forum that looks at what the implications are from an international standpoint on the data collection. Again, you know, the choice principle, it gives the individual's opportunity to opt out, but we obviously have our opt-in mechanism based on the fact that we have the GDPR as the golden standard or as a global corporate standard, except where local law is stricter. And then aside from that, that's from an internal perspective in terms of we're not really jumping up and down about it, but it does help with international transfers in some way, although we still have the SCCs embedded into our intragroup agreements. Externally within my network, we were discussing this, you know, a lot of us meet up and discuss these things, and they've said that it's impossible to comply with every privacy framework and privacy law that pops up. And they're leaning a lot more into that risk-based analysis of what are our real gripes here? What is the real risk for us as an international organization? And one colleague, trusted friend, actually said that, you know, for them, their biggest issue right now is the consent requirements across Asia Pacific. You know, it's that patchwork of privacy laws and having different regions and notification obligations in Asia Pacific as well. And for them, they'll stick with the SCCs, but is this something that they should be worrying about or looking more closely to? Because right now they can't really pay much attention to what's happening to the data protection reforms in the UK because it's so, you know, all over the place. So from an in-house perspective, we've got our own programs, and we actually embed the hide strategies when we're looking at a privacy in engineering perspective. So when we're looking at system architecture, and how our databases talk to each other and what we're doing with things like personalization and the data that we hold from a member's perspective. And I've spoken about this before on other webinars and things, we do the hide strategies. Now, the hide strategies are actually mainly used in the US, and they are data-oriented strategies and then process-oriented strategies. So the data ones would focus on things like security that we find within the 7 main principles of the UK-US data bridge. And it looks at things like separating, stripping, obfuscating, hiding data, and what you can do with personal information to be able to give it adequate security, but also allow you to use it in quite innovative ways. And then with the process-oriented strategies is what we see again within the UK-US data bridge in terms of the accountability principle and demonstrating and showing both externally and also within your own organization in terms of employees, how you actually manage the data and what you do to safeguard it. So we're seeing basically this being reiterated and it is a patchwork of different requirements, but and possibly coming together holistically under the UK-US data bridge. But let's just say we haven't got the cheerleading routine down just yet for the UK-US data bridge. But yeah, that's my own perspective. Thank you, Rob. Thank you, Marco.
Oh, right. It was awesome, like the perspective that you both brought, because it actually covers both the view of someone that I worked internally for a specific company and someone that also giving advisory for different types of company, but the challenges are the same. We can see that basically we have like some structural and fundamental points that we need to pay attention in terms of the current monitoring and the ongoing surveillance of your program, like the choice, the consent mechanism, the opt-out portal, and how you are also putting like those recommendations in your BCRs, in your agreements. And I think most of the questions that we received from the audience while you were both explaining about it covered those points. And to wrap up, like in our 10-12 final minutes that we have, I will pick up a couple of questions, and I would appreciate if you both could contribute like 3-4 minutes answering parts of the questions. So for both Tumi and Robert, like first question, it's about the consent review. So it's felt that we should have a periodic review of the consent given by the data subject based on the provisions of the framework. But the current provisions in different ACTs do not provide for such reviews. So can you please comment on this? So I believe that they want an answer about how we will balance this periodic review that the framework obliges, but also depending how you are establishing your formal instrument, your agreement, or even your internal policy, you do not have established this type of review in your business.
Can you repeat that? Sorry. Or Rob, do you want to go first?
Well, I think, well, correct me if I'm wrong, Marco, but I think this is how sort of the consent requirements have been defined under the framework compared with what we've got under the UK GDPR and also under the sort of proposed amendments that are coming through. And yeah, again, I think you can, as not a lawyer, so I have a legal background, but I can sort of hand on heart say I'm not a practicing sort of legal professional. You know, I think you can lose yourself a little bit in trying to split hairs or look at variations or difference in definitions here. I think fundamentally, if you're relying on consent, it's got to be legitimate, it's got to be fairly given, it's got to be collected in a way that, you know, there isn't sort of undue balance of power between the parties, that sort of thing. Some of that is written in the law, some of that has come out of guidance by the ICO or the other European Data Protection Authorities, or now the EDPB. Yeah, I think that the point about periodic review of consent, I don't think it's necessarily a new one, but I think it's evolved out of situations we had, particularly under digital marketing and issues around opt-ins, opt-outs, and the likes, about people holding databases which are just wholly sort of out of date, or acquiring things where consent had been obtained 10 years ago, and that was being used as a basis for a third party to be able to then use that data. So I think it's quite subjective to actually the nature of the processing that consent is being used for. and that in itself may very well justify different periods at which you should be reviewing the validity of that consent. So I think in many ways, if you haven't already got anything, you're probably not going to change your risk profile insofar as it's at least sort of an implied obligation I would consider under sort of even the UK GDPR. But I think it's about managing risk. It's about your stakeholders, be it the data subjects, the internal users of the data, or your external sort of regulators and investors. Where is the harm going to come from? Looking at the nature of those relationships, should you be reviewing your marketing sort of opt-ins on an annual or an 18-month or a 2-year basis? In other instances, is it better to review that when there is a periodic change in your contract with that party? Be it provision of financial services or whatever. Again, I think it's something is worth looking at in terms of the scope of how your current privacy policies and procedures look at that. But I don't think effectively the data privacy framework is creating any more exposure in that relationship than already exists under our current sort of data protection rules. But Tumi, I don't know if you've got sort of other thoughts or ideas on that.
Yeah, I've just got what the perspective is of what we do internally. So obviously we have product in productwillcover.com and also the app. So for example, with us and consent reviews, what we've done in terms of digital marketing and even personalization is that we do a lot of the consent and opt-ins via the app, which is through the personal preferences and privacy preferences. So we do a lot of push notifications, and when there's a certain change to how we want to market or what we want to try and personalize for the individual, we do periodic reviews in terms of making that a two-way street between us and the member. So, we'll send the push notification saying we're making changes to this, and this. Do you want to update your preferences? Are you still okay to hear from us in this particular way? So as well as going out there, we also provide a privacy preferences portal with which you can actually go in there and update any preferences. And we have obviously opt out, but also opt down, which is something that the DMA have spoken quite frequently about in terms of allowing individuals, members, users to be able to really toggle with their preferences and making sure that, again, consent is not that statutory thing. But that's just from an in-house digital product perspective in terms of reviewing the consent, but making it more of a live activity that you take the individual on a journey with you, not just, something that's quite arbitrary and statutory. But that's just a brief, quick add-on from what Rob has given from a consultant perspective.
No, I think it was really helpful, and I hope it answered the question, because it got quite clear that you don't have like an extra requirement, but if you are complying with a global perspective, like we have the GDPR, the consent requirement, so there's nothing new. Actually, you just need to use what you already have in place to collect the consent in the right manner, like depending the framework that you are adopting. And you just need to use the same type of procedures, the same type of instrument as how you will disclose that you are complying with the choice principle overall in the framework. So we have time for a last question, I believe. And now this question is more related about the redress mechanism. So there's a question about a scenario that someone is asking from the data fiduciary perspective, if a customer has exercised its right to erasure, but we have regulatory requirements to retain data for a certain period of time, what are the steps to be followed, and what could be the impact on cross-border relationship? So whoever wants to answer first, Tumi or Robert, I believe that you both are familiar with this case when we're recommending how to balance like legal requirements and the cross-border data transfers, because the framework also has this type of solution, I think, when you can justify the retention if you have like a legal obligation to maintain the data.
And that's not something that is new or has added complication as a result of the UK-US data bridge. And it touches on a number of things that are obviously important from an organizational standpoint in terms of how you actually organize the information. So in terms of policies, making it clear that exemptions do apply to that right of removing information, and ensuring that the individual is very clear and understanding of that. And then also in terms of internally and how you manage information, making sure that if it is needed to be retained for a particular purpose, that obviously qualifies as an exemption, then individuals within the organization who are responsible for the management of that information are also understanding or aware of that obligation. I mean, Rob, have I missed something?
No, that all makes sense to me. The only thing I would quickly add is it gets a little bit more complicated if your obligation as a global organization is based on a legal requirement outside of the UK or Europe. So again, it wouldn't be your typical situation with a data transfer under the data bridge sort of scenario. But, you know, we deal with sort of clients where they're involved in, for example, cross-border litigation and claims. And there may be situations where essentially data has to be shared, but there are, say, for example, US legal requirements to retain that data that vary from the EU rules. And under the terms of sort of the GDPR and the provisions and exemptions, you can't rely on third country legal requirements as a justification for that. But again, you know, it's balancing up risks and obligations and responsibilities, and managing the best outcomes.
I think, Robert, you took a very important point, because data retention due to legal obligations are something that it's quite similar overall in any kind of global privacy law. So if you think about the standard that GDPR created as a privacy omnibus law, and then we go to Latin American like Brazil, LGPD, or even in North America like the PIPED in Canada and the South African law, like we have this kind of repetition. But one point that's quite clear is that if we are assessing specifically in this framework and you have like this channel between the UK and US, one point that's really important, it's about the territorial scope of the law that you are using to justify the data retention. So we can go back like to the fundamental lessons of the law school and understand about the territorial scope, because then this is not just privacy, it can apply to any kind of law. So if you can justify the territorial scope, if you can justify that you have this obligation regarding this specific law, and you can specifically justify the retention of this asset, then you have, like, I would not say that you can 100% guarantee this retention, but you have at least the fundamental pillars to create your internal legal justification to actually use the legal obligation as your fundamental lawful basis for data retention. But as Robert and also Tumi explained it, it's not a straightforward answer. Like, you need to assess all those variables that we discussed here.
Yes.
So I don't think we have time for another question, as we are already going to the end. So I would just open for final remarks, and thank you all our attendants and all our speakers here too, because we had several insights that I believe it will help business like to tackle the challenge about this framework. And just to wrap up, and as final remarks, I can give 1 minute for Tumi and 1 minute for Robert if you have any kind of final comments and final advisory for our audience.
We never really got to touch on it, but I guess in terms of any possible reversal of approvals that have been given, and some of the exciting changes that we see with the UK legislative landscape as well. We were all talking just before the webinar, weren't we, about the fact that there were some amendments tabled within the UK Data Protection Bill that are quite alarming. So as we see MPs vote on that, I guess we'll get a flavour for what is to come in terms of UK data protection reform, and then how that impacts relations with the EU, and as a result, obviously, the EU, US, and the UK extension data bridge. But Rob, please.
I'll keep it very quick. I think, my view is, unless there's a reason why you want to be different, there's there's a logic in being in the pack. So doing enough that you don't bring yourself attention to regulators or class actions or whatever, but just, also not trying to gild the lily or boil the ocean with some of these challenges, particularly with managing sort of international data transfers. So, my only advice is really, depending on the maturity of your organization and your program and your resources, look at priorities around where your biggest exposure is and the types of processes and controls around it. And definitely the data bridge can form part of effectively that framework. But yeah, really understand your organization and not try and lose too much sleep that you're not necessarily doing everything.
All right. So thank you very much, Robert. Thank you, Tumi. And I hope everyone enjoyed the insights that we had here. And if you have any questions or any kind of comment that you want to forward for us, please send an email for the OneTrust team, and we will be happy to answer. So thank you very much, and have a nice day for everyone.
Thank you.
Thanks, everybody.